A stockholder has the right to inspect a corporation's records for possible corporate wrongdoing, but only if the stockholder has a proper purpose. But what constitutes a proper purpose? And how does a stockholder show that a purpose is proper? The Delaware Supreme Court explored these questions in Amerisource Bergen Corporation versus Lebanon County Employees Retirement Fund. Amerisource Bergen was a major opioid distributor. The company was the subject of several government investigations and multiple lawsuits for allegedly violating the law by fulfilling suspicious and likely illegitimate opioid orders. The accusations spanned several years, and the company's potential liability exceeded $100 billion. Lebanon County Employees Retirement Fund owned shares of Amerisource Bergen. The retirement fund and another stockholder served a book and records demand to inspect Amerisource Bergen's corporate records. The demand's stated purpose was to investigate possible corporate wrongdoing related to illegal opioid distribution, to evaluate the board members' independence, and to use the information obtained to evaluate possible litigation or other corrective actions. Amerisource Bergen refused to produce any records. It argued that the demand was invalid because the stockholders hadn't been specific about how they intended to use the information and because any litigation claims for corporate wrongdoing would fail. The two stockholders sued to compel Amerisource Bergen to produce its records. The Court of Chancery found that the demand stated a proper purpose for inspecting corporate records and was valid. The court ordered Amerisource Bergen to produce formal board materials. To help determine which informal board materials and officer-level records should also be produced, the court ordered Amerisource Bergen to produce a representative for a deposition about the company's record-keeping practices. Amerisource Bergen appealed to the Delaware Supreme Court.